So, we begin tonight for real with breaking news out of Massachusetts. Big breaking news. A federal judge has ruled that the government's ban on same-sex marriage is unconstitutional. A bombshell. U.S. District Court Judge Joseph Tauro decided in two separate cases late today that the Defense of Marriage Act violates the fundamental principles of this nation. And with that, the judge made advocates of marriage equality very, very happy. One of the rulings involves 7 gay couples and 3 widowers, all of whom have been married in the state of Massachusetts, and all of whom have been ineligible for the federal benefits that come with being lawfully wed, thanks to the 1996 Defense of Marriage Act. That law required the federal government to ignore, for federal purposes, any marriage that was not between a man and a woman. That means same-sex wedded couples have no access to family health insurance if one works for the government, no Social Security survivor benefits, no joint filing of federal taxes. Now, there are 2 salient things about the rulings. First, Judge Tauro granted the plaintiffs what's known as summary judgment. Both sides filed their arguments, and the judge looked at them. He decided he didn't need to hear another word. Judge Tauro saying the government's rationale for DOMA, quote, strains credulity, and that, quote, irrational prejudice plainly never constitutes a legitimate government interest. Judge Tauro ruled that a key part of DOMA violates the couple's 5th Amendment right to equal protection. That's salient fact number 1. Point number 2, Judge Tauro also ruled for the Commonwealth of Massachusetts, saying the federal government wrongly forced it to discriminate. Tauro writing, quote, the federal government, by enacting and enforcing DOMA, plainly encroaches upon the firmly entrenched province of the state and, in doing so, offends the 10th Amendment. Offends the 10th Amendment. Whoa. Now, the 10th Amendment is the Don't Tread on Me Amendment. The 10th Amendment is to right-wingers what the First Amendment is to the ACLU. The 10th Amendment, that's the one conservatives are using to try to repeal health reform. It's the one the violent fringies use to declare themselves sovereign citizens, not subject to the law of the land. It's Texas Governor Rick Perry's favorite battle cry. And now, today, the 10th Amendment means gay couples are one step closer to being treated equally in this country. Don't tread on them either. Joining me now is the Massachusetts Attorney General Martha Coakley, who filed a lawsuit challenging the Federal Defense of Marriage Act. Attorney General Coakley, thank you for being here.
My pleasure.
Now, it was exactly 1 year ago today you filed a lawsuit. What does today's ruling mean for the plaintiffs in this case as of tonight?
Well, for the plaintiffs and for Massachusetts, it means that everybody in Massachusetts who's married will be treated the same. That was our argument, of course, on behalf of the Commonwealth, that we didn't want to have to keep 2 sets of books and discriminate against our citizens who, under Massachusetts law, have not that restrictive definition of marriage, but a marriage that says by our Supreme Court since 2004 that same-sex marriage is allowed in Massachusetts. In fact, it's required under our own Constitution, also written by John Adams. And so we're delighted with this ruling because it means now that there's a lot of things we don't have to do. We don't have to keep a separate set of books for federal benefits that come in through the state. And that includes everything from Social Security to medical benefits. Veterans can be treated the same way. And of course, for the plaintiffs in the suit, it means that they will be treated now as our opposite sex couples are in Massachusetts.
Yeah, well, you just mentioned this. Talk a little bit more about what the sort of the kind of entire category of those benefits are. I mean, I think that it's easy to lose sight of just the amount of benefits that accrue to married couples. What are we looking at in terms of what that category of things are?
Well, it's a whole range of things, and it includes everything from Social Security to how you file your income tax to what kind of medical benefits you may be entitled. If your spouse is a federal employee, the retirement issues may be very different. And so there's over 1,100 different benefits, ways in which federal law would treat somebody differently here in Massachusetts. And frankly, it is difficult for Massachusetts. It's a burden on Massachusetts to try and keep those 2 sets of books, because for some purposes you're married under our law, other purposes you're not married under the federal law. Judge Tauro's decision changed that today.
So this is a decision in federal district court. What is next for the case? Is it reasonable we're going to see an appeal?
That's up to the government. Obviously, it's not our call, but the decision has not been stayed. It's now effective, and it means, obviously, we're going to work with our state agencies and with people in Massachusetts to make sure that we can implement this. But this is now the law in Massachusetts that all married couples will be treated the same for federal and state benefits.
Finally, I want to press you a little bit on something you said today. You said today that it's, quote, unconstitutional for the federal government to decide who is married. That seems to me to open the door to a kind of double-edged sword, right? Because presumably we might want some federal law passed that actually institutes marriage equality, and it seems like that argument could then be used by states that don't want to grant it to deny federal marriage equality.
Well, we don't agree with that. Keep in mind that this has to do solely with what Massachusetts has already done, which is extend civil rights as we believe it should be. We hope, by the way, that this leads to the extension of civil rights throughout the country. We don't think it will cause the shrinking of them, but Massachusetts has decided that. And what we said is that the Congress cannot now, by a statute, change what Massachusetts has done. The reverse isn't true. It doesn't mean that it will affect other states right now one way or the other. It just says that Congress cannot pass a law that the judge found has no basis but to discriminate. And that's key in this. We're talking about civil rights here and what Massachusetts has done. So we don't think that, we think it's a good effect for Massachusetts, and we hope, frankly, it'll continue the discussion for marriage equality as civil rights across the country.
Massachusetts Attorney General Martha Coakley, thank you so much for being here.
My pleasure. Thank you. Have a good night.
Joining me now is Tobias Wolff, law professor at the University of Pennsylvania. Mr. Wolff was also chief advisor to the Obama presidential campaign on LGBT issues. Mr. Wolff, thanks so much for being here.
Thank you for having me.
So let's talk about the Obama administration. The president finds himself in an interesting sort of bind here. He has officially stated on the record that he's against DOMA. His representatives in federal court argued for DOMA in this case. What do you see as being the decision procedure in deciding whether or not to appeal here?
Well, it's going to be difficult for them not to appeal. And this administration is frankly has been put in a rotten position with respect to this statute. On the one hand, the president doesn't just oppose the Defense of Marriage Act. He has announced as a priority of his administration 3 times on live TV from the White House that he wants Congress to repeal this statute. It's a discriminatory statute. He's been saying that for years, and he wants to get rid of it. That commitment runs up against another very important principle, which is the obligation of the Justice Department to defend statutes that are already on the books if they think that there's a reasonable argument they can make. And reasonable minds can disagree about what their obligations were in this case, but I think it was not an unreasonable decision on their part to say we've got to mount a defense to this statute. So when the question comes, are they going to appeal this case, they're kind of faced with the same dilemma. Now, I will say this. There was a press conference earlier today that I was able to sit in on by telephone, and the lawyers for the DOMA plaintiffs actually said the same thing. They said it would be difficult for the federal government not to appeal at this point. But the more judicial decisions that we get, like today's, which help to establish in the courts the principle that anti-gay discrimination and discrimination against relationships of gay couples is unconstitutional and impermissible, the more ammunition it will give the the Justice Department to perhaps take a second look at that question.
Let's talk about the next steps. I mean, this will likely get appealed.
Yeah.
It seems to me, and I'm an amateur in this department, that it's going to end up in the Supreme Court. It's that kind of case, I would imagine. Is that what you foresee? And could we be faced with a fascinating situation in which Elena Kagan is sitting in on the court on exactly this case?
Well, certainly the next stage is that the case goes to the First Circuit Court of Appeals. And if the plaintiffs win before the First Circuit, so the First Circuit strikes down the statute, I think it's quite likely that the court will decide it has to take the case. But, you know, in figuring out what the implications are of this case, it's important to keep in mind what it does and doesn't decide. And I want to clarify one thing that you said at the top of the show.
Please.
This isn't a case about the constitutionality of excluding gay couples from marriage. Nothing in this case has to do with whether states have to let gay couples get married. What this is about is where you've got states, currently 5 states plus the District of Columbia, that let gay couples get married. Can the federal government treat their marriage marriages differently from everybody else's marriages. And I'll tell you honestly, whatever the court's approach to the marriage question is going to be, if they ever are called upon to decide it, this is a question that seems much harder to defend, right? That you've got couples that are married under state law. This goes back to part of what Attorney General Coakley was saying. And the federal government is requiring discrimination and interfering with the state's own decision about the couples that they want to see getting married. So I don't think that we should make any quick assumptions about how this court would decide the case. And of course, there are federalism issues in this case, too.
Tobias Wolff, law professor at the University of Pennsylvania, thank you so much for joining me on set.
Thank you, Chris.
I appreciate it.
You bet.